If you are going through a divorce or you're potentially going through a divorce, you probably have questions about property and how courts handle property. Is the property yours? Is the property your spouse's? Is it going to be divided by the court? Today, I'm going to do a video breaking down the most common questions about separate property and marital property and how the court figures out who gets what in a divorce. My name is Jenni Brown, and I am the founding partner of Brown, Dutton, and Crider law firm in Marietta, Georgia. Let's talk about separate property first. There are a few different types of separate property that fall under that umbrella in Georgia. The most common ones you've probably heard about are inherited property, gifted property, and then the big one that we have to deal with all the time is premarital property. So let's break those down a little bit. Inherited property is a form of separate property. And here in Georgia, if you inherit property from your family and you keep that property separate, meaning you don't commingle it in a joint bank account with your spouse, you don't add your spouse's name to that, that is typically your separate property. And what that means is in a divorce case, your spouse is not going to have access to that property. They're not going to be able to make a claim for that property. So let's say that one of your parents pass away and you are inherited a piece of property. You do not add your spouse to that property. You don't use marital funds to support that property. Then that piece of property, it's usually a piece of real estate. It might be a IRA account, an investment account, something like that. That is maintained as a separate asset and it's not subject to division in the event that you get divorced. Where inherited property gets really sticky is when someone commingles it. So let's say that you have somebody in your family pass away and you are inherited a investment account. And then you take that money and you put it into a marital home, or you transfer it into a different account that is titled in both parties' names. Here in Georgia, we call that commingling, and then it becomes a marital asset. So the best thing that you can do is if you have inherited property, you want to keep that separate, only in your name and not combined with a marital asset, so it maintains its separate status. Another form of separate property in Georgia is gifted property. This means if somebody gives a gift directly to you, the spouse, it is typically also not marital property. So if someone gives me a car for my birthday, and let's just say my parents gift me a car, they put the title in my name, they pay for the vehicle, and I'm not putting marital funds towards that vehicle, then that is my separate property. Let's talk about the big one. Let's talk about premarital property. If you are getting married and you have assets already, then those assets are yours and they're not subject to equitable division. Now, as you can imagine, this gets really tricky sometimes because you might be married in your 20s and you just started a 401k account or an IRA account. And then you're married for 20 years and maybe you're divorcing around 45 and that account has grown substantially. Well, it is still really important to figure out what is your premarital property. And the premarital property in that situation would be whatever you had at the time of marriage, but also the growth on that amount from the time of marriage. And this is a huge opportunity that many people miss out on because they just look at it and say, okay, well, when we were married, I knew I only had $5,000 in that account. So it's not a big deal. But wait, it's a huge deal because that $5,000 could grow to $50,000, $60,000, $100,000, depending on what happened in the market and how long you were married. So you want to make sure that you are really familiar with premarital property, how it's calculated, and how to maximize that in the event of a divorce. Now let's talk about marital property. In Georgia, anything that is accrued, meaning earned, during the marriage is considered marital property subject to equitable division. Now, that's a lot of words. It essentially means that the court looks at what is fair in this particular situation. Usually, what is fair is that the property is split 50-50. That's not always the case. And it's very abnormal for the court to look at each asset individually. Usually, we're going to look at everything globally and figure out what is the best way to help this family moving forward and divide the asset as equitably as possible without actually physically splitting each individual asset. If you own a home, or maybe you own multiple homes, you probably have questions about what is going to happen with our real property, our houses, if we are going through a divorce. Ultimately, it comes down to the court having three choices when there's a piece of property at issue. You keep the property, your spouse keeps the property, or the court orders that the property is sold and the equity in that property is split in some form or fashion, typically 50-50, but not always. If there is a house involved, the court is going to consider a multitude of factors in figuring out who should keep the house. Are there children in the house? Do we need to provide consistency for those children? How is the mortgage titled? Because the court is going to want to separate financially the spouses as much as possible. So, if you own a house and if it is titled jointly and there's a joint mortgage and you would like to keep the house, a huge question the court is going to have is, are you able to refinance the mortgage and remove the other spouse from the liability? And on top of that, if you can, are you able to pay out whatever their equitable division is? And if you're not, then it's probably not a reality that you keep the house. They're going to go through that same analysis if your spouse is asking for the house. And many times the reality is that you can't afford it and the house has to be sold. And the reason is because if you've got two incomes going in to support one house, it's a lot easier to float. But when you're in a divorce situation and you've got a child support payment, possibly an alimony payment, and a loss of one of the income streams, then it's not as easy to keep that house and certainly not as easy to refinance the mortgage and pay your spouse out. So, the common thing that will happen is if refinancing and removing the liability is not a possibility, the house might be sold. Let's talk about vehicles. Honestly, I think a lot of the times judges don't want to talk about your car and who gets your car. But at the end of the day, it is an asset. So, what we typically like to do is include that on a balance sheet and look at it as far as a global equitable division. And it might be an important step in the process. So, let's just say you have a Ford F-250 and it's paid off and it's worth $70,000 and your spouse is driving a Toyota Corolla and it is an old Corolla and it's worth $3,500. Well, it would not be equitable to say you each just keep your own cars and they're not counted. What we would do is we would say, okay, you keep the Ford F-250, we'll keep the Corolla or vice versa, but we've got to equalize it out from somewhere else. And then we try to look at where does that make sense? Is there an extra bank account? Is there more equity in the house? Maybe a little bit more from retirement. But the court is typically going to leave a vehicle with the party that is driving the vehicle. A big bone of contention in Georgia is, what do we do with our pets? Well, the court looks at pets just like property, but you can't divide a pet, meaning the court is not going to timeshare a pet like they would a child. The court is going to either award the pets to spouse A or spouse B. So if you are thinking that you might be fighting over the pet and ownership of the pet, you definitely want to get together your evidence of, okay, who is the one who purchased this pet in the first place? Who is the one who takes the pet to the vet? Who is in charge of any boarding? Who is taking care of the animal when it's sick? Who is emotionally connected to the pet? But a big factor is also who's having primary custody of the kids and what is the kid's relationship with the animal. Another thing that the court has to consider when they're looking at pets and who's going to keep a pet is, what is your living situation? Are you in a rental that even allows pets? There's a lot of questions surrounding pets, but at the end of the day, the court views pets as a piece of property and it's going to be awarded to one or the other spouse. Let's talk about investment accounts and retirement accounts because many times these accounts go hand in hand. First and foremost, if you're putting money into these accounts during your marriage, it is marital. Georgia is not ruled by title, meaning if the account is in your name, that doesn't mean you are just entitled to it because it's in your name. Also, if your employer is matching into those retirement accounts, which we frequently see, then that's also a marital contribution, meaning it's a marital asset subject to equitable division. However, something that people worry about all the time is what are the tax consequences? And am I going to be penalized because we're not old enough to draw from these retirement accounts? And the good news is you're not. What the court does is they sign something called a qualified domestic relations order. And if the account is divided, so let's say you've got a 401k, and the way it shakes out is that 401k was earned completely during the marriage. So it's 100% marital. And the court says, okay, that particular account is going to be divided 50-50. What the court does is they sign a qualified domestic relations order, and that goes to the actual provider. So let's just say it's a 401k, that is through Fidelity. Fidelity will get a court order that says, okay, Fidelity, you are ordered to divide this account 50-50. So what they will do is they will physically split that account. The person who is employed with whoever supports the 401k, their 50% will remain intact. And then the spouse will actually get a separate account in their own name, and it will be converted to a pre-tax IRA, but neither party will have taxes or early withdrawal penalties because it's subject to a court order in a divorce. Let's talk about insurance and how that works post-divorce and during a divorce. Here in Georgia, when you file for a divorce, something called a standing order goes into effect. And what this is it's kind of a freeze, right? Don't make any huge changes. You're not allowed to remove your spouse from insurance. You're not allowed to sell a piece of property, and you shouldn't be liquidating large amounts from any accounts outside the course of what your regular business is. Now, post divorce, that's different. Employers are not going to let you stay on your spouse's insurance post divorce. So the court is going to have an expectation that you each get your own health insurance post divorce. Now, your employer might have benefits where for some period of time, you as a spouse can pay for that insurance. Usually it's more expensive than it is to just go out and get your own policy. But this is something that you're really going to want to look into because it's a huge factor. We all know how important health, dental, and vision insurance is. But we also know that when the divorce is granted, you are not going to be able to stay on that same policy. Now, that is not true for your children. Your children are going to continue to be able to be a dependent on whosever policy covers the insurance. And the court is going to expect that insurance continue to be provided for children post divorce. A common question that actually comes up is, do I get the wedding ring back? And the answer in Georgia is pretty clear. If the ring was an engagement ring, you don't. Because what the court looks at that as is they say it's a gift in contemplation of marriage, meaning you made a promise to marry me, we got married, and now I earned the ring. This is a really hard pill for a lot of people to swallow, especially if the ring was a family heirloom that was gifted or something like that, or if it was just really expensive, right? You proposed, your marriage didn't work out, you'd like the ring back. But unfortunately, in Georgia, that is considered separate property and you don't get the ring back unless the other party consents. If you are going through divorce, one of the biggest and scariest issues that people have to deal with is what is going to happen with our debt and who is going to be responsible for it. Am I going to be solely responsible for it? Is my spouse going to be solely responsible for it? And how is it going to get paid? First, let's talk about separate debt. Debt is looked at from the court's perspective very similarly to assets. So if it was debt that you had before you got married, then that's your separate debt. Your spouse is not responsible for that, and it will not offset the marital estate. If debt was accrued during your marriage, then it is typically marital, subject to equitable division. Now, this could mean 50-50, or the court could look at it and say, okay, one party makes substantially more money, so they are going to have a burden of a bigger piece of this debt. The court also has broad authority to just say, okay, I'm not going to consider that debt, or I'm just going to make that your separate debt. And many times this occurs when it's student debt. Usually, if you have student loans, the court is going to keep those student loans with the particular person that they've benefited because you are going to be the individual that benefits with those moving forward. Now, that's not always the case, and ultimately that is up to the court, but it is something that we frequently see. Let's talk about secured debt and unsecured debt. Big picture, secured debt means debt that is secured by a certain asset. So, some examples of secured debt would be a mortgage, a HELOC, a car loan. Unsecured debt is debt that is not secured by any particular asset. That would be a personal loan, credit card, tax debt, assuming there's no tax lien. Those are all examples of unsecured debt. The court is going to look at secured debt through the lens of it just offsets the asset. So if there's a mortgage, for example, and the mortgage was taken out during the marriage, then that is going to reduce the value of the actual house it's attached to. So if you've got a $500,000 house and a $250,000 mortgage, then your house is actually only worth $250,000. And that's the amount of equity that the court is looking to figure out what do we do with. Now, here's what's important. Any joint debt, the court is going to want to figure out how do we get this in one party's name or the other. So, in that same scenario, if you have a $500,000 house and there's a $250,000 mortgage and you want to keep the house, the court is going to say, okay, well, do you have the ability to refinance and to remove your spouse's name so that we can make sure they are no longer on that liability post divorce? Credit cards and personal loans are unsecured debt, but they are still marital debt. This can get ugly in a divorce case, especially if the parties are not on the same page about spending and if they haven't been upfront with the amount of debt that they have accrued. So typically, this is included in the marital balance sheet to figure out what each party is entitled to. But usually, the credit cards will stay with the named party, and that named party will be responsible for it. However, that does get offset by the assets in the case, unless there is egregious behavior and spending that is completely considered not marital. The court has broad discretion in what to do with this, but typically they do make the party that has accrued the debt stay responsible for it post divorce so you don't have those financial ties after the separation and once the divorce is finalized. The reason that the court likes to separate your finances post divorce, where you're not both on a particular debt, is because the creditor doesn't care. Let's say that you've got a mortgage with Wells Fargo and it's a jointly titled mortgage, and your spouse was awarded the house. The agreement says that they're solely responsible for it and they stop paying for it. You're still on the house, you're still on the liability, and Wells Fargo is ultimately going to come after both of you. So the court tries to make sure that these financial ties are severed so that this is not a possibility, because ultimately what it ends up leading to is continued litigation. I hope that this has answered some of the pressing questions that you have about what happens with assets and debts when you're in the midst of a possible divorce. These are common questions that many people have when they're going through divorce, and I am here to answer some of those common questions. So feel free to leave them for me. You can leave them in the comments or send us a message, and I will be happy to get out any general information or videos I can.